continuum you have to look at. So it's not a continuum, it's not just a binary choice. So even though you argued as applied, when you look at the principles under it on the continuum, this is truly a facial challenge. And we had tried to talk a little bit about that in the Simpson case, that the as applied, it wasn't just that organization, but it was a category. Not quite facial, but a category. Didn't get a whole lot of places with that argument. So what I would say is, I think, litigants, people seeking to comply, I know that the Secretary of State's office is mindful of this, and I'm sure, the courts are mindful of this, but when you look at this, I think it's important to be mindful of how does this apply to people in the future as well, so that all of us, Ed's clients and my clients out there, we can say, yes, you can do this, or no, you can't do this. And we're not stuck in a position where our client says, well, you say I can't do this, but them over there on the other side, they're doing it. And I say, well, life's not fair. No one on our side is going to sue them. People on their side are going to sue us. And even though the court said that, it's got no precedential value, and it may or may not apply here. So you pays your money, and you take your chances. So that becomes a real, I think structurally that's built into, the fact that Amendment 27 was an amendment, it's Article 28 of the Constitution now. And you don't have a consensus within the legislature on the direction to go on this stuff, because we do have a split legislature. And even sometimes when you do have a consensus, you have a legislator that enacts laws that the consequences are uncertain, shall we say. I mean, even now, you now have this legislative thing, these small issue committees, what do you call them,
Small scale.
small scale issue committees. Because they can't just be 3 words, you have to have 4 words, it has to be small scale issue committees. I think that's going to take a while for people to truly figure out how that gets applied, just because it's a challenge here. And then you've got the First Amendment overlay. So it becomes a very difficult thing. There's a case going on right now that says, hey, this whole enforcement structure, modified body, that in itself creates a level of uncertainty and chill speech. From my perspective, I can guarantee that does happen. We'll see if the courts agree with that on that case. So it could wipe out our whole current enforcement system, at which point it would have to be replaced with something that's hopefully provides a little bit more clarity for people.
That case is probably one of the more interesting ones. I'm not going to give this microphone back to Matt because he's arguing that case at this point. But, there's a case where the Holland case, which is pending now in U.S. District Court, right? Still, yeah, so it's got a ways to go. The main thesis of that case is that for a small group, forget about constitutional conflicts and whether the Secretary of State has the power to do this or that, but the entire, the complexity of the campaign finance laws is just plain too much. And it would not necessarily be too much if there were a prosecutorial discretion, if the Secretary of State were the enforcing officer, because they could look at it and say, well, we're just not going to proceed with this. But it isn't like that. We have this private right of action, which is very populist in nature, where populism can come from both sides of the aisle. This one came from my side primarily. But we have this private right of action where anybody can come in the door with insane stuff. And it may stop and die, and I've certainly been in the administrative courts and seen it happen where judge will just say, no, this is the end of it. We're not going to even apply the law, forget about the constitutional issues in this fashion, and here's why. And the case pretty much will stop there. But still, at a bare minimum, something either, I guess there are 2 categories.
You still have the cost of defense.
Well, that's where I'm going.
You still have the political ramifications and the accusations.
There are 2 categories of these kinds of cases, I think. One are just the crazy ones. You get in there, and I'm looking at the judges out here, and I've seen your faces on occasion from the bench, like, is somebody really arguing this? And you all handle it with great consideration for those in front of you. But there's another kind, too. There's just the gotcha cases which go on, and sometimes they're politically motivated. Some of them, some of the primary gotcha engines in the campaign finance enforcement area are very bipartisan, as it has turned out. I'm not quite sure why, but Scott's shaking his head. Nevertheless, these.
Some hate both sides.
And-
There's one person
well,
who
yeah, I
hates
know.
both sides, one.
Okay. Putting that individual aside, at a bare minimum, a very small group of people have to go through a process which involves this immediate referral to the administrative courts. They have to show up for a hearing. They can't not show up or file something. They fear or sometimes feel they have to hire a lawyer. I mean, that's enough in itself for a small group to give us concern. And I think many of us would like, I mean, I know where this is going. And I'm not gonna ask Matt because he would have to preview his arguments. I'm not gonna ask Scott because we'd get into an argument about it. But it's a concern. And I mean, that case is, the Holland case is now out there. We've got some other cases out there. I'm just gonna throw a couple out and Scott can weigh in and comment as he wishes. There's a case out there now where I think the administrative courts did the right thing. Court of Appeals flipped it upside down and said that use of attorneys, either on a pro bono or reduced fee fashion, amounts, Scott shaking his head, we may agree on this, constitutes a contribution. Even if the attorney's services were not necessarily related in any way to advocacy for or behalf or promoting the campaign of a particular candidate or whatever the mission of the committee is. In this particular case, as I recall, the one that the Court of Appeals reversed the administrative court on involved an attorney who filed a termination report for a committee. I mean,
Let me just jump in and just say a little something about that. 'cause
I'm not done, but I'll let him jump in.
All right, if I may just sort of talk about the practical impact of that.
Well, we can all see that.
Well, but here's what happens.
You and I are out of business.
Well, and it's not just that, but you got some schlep candidate out here, okay? And they can collect $400 per person, okay? $400. Let me tell you, politics you don't get rich in, okay? So they're collecting $400 a person, and they go through this campaign, and they like spend all their money, and then they like loan themselves some money too. So they're out of money. And just towards the end of the campaign, when it has maximum political effect, they get hit with a campaign finance lawsuit. Now, this stuff is complex. I think everyone would agree with that. So now what happens is they can't even get attorneys to help them out on a pro bono case, on a pro bono basis, which is probably the only area in entire American society where attorneys are not allowed to help someone pro bono, okay? So now they can't, and so whatever your rate is, so I'm gonna say, let us stipulate that Ed's rate is $200 an hour. We'll stipulate that. He spends 2 hours.
It is.
Okay, he spends 2 hours, which is enough time to open a file and look at the case and maybe get a sense of framework and call your client, tell them what it's about. Boom, 2 hours are up. You now can do no more because otherwise you're going to exceed the contribution limits as an attorney. And so now the candidate has no money, has no pro bono support, and walks in pro bono to defend himself or herself from this campaign finance complaint. It's just crushing that.
Don't miss the equal protection context of this. So while Scott's running for office the next time and trying to get some attorney assistance, and he doesn't have the money to pay their fees because it'll eat up his campaign war chest, and he can't
War
accept.
chest is very gracious to say that.
He can't accept reduced fee or pro bono work because those will be deemed contributions, will blow the limits with in-kind contributions right out of the block. So he's stuck. I, on the other hand, whose mission in life is to prevent Scott from being elected to anything, of course, represent the dark side.
Evil independent expenditure committee.
Represent the independent expenditures committee is going after. They have all the money in the world, and I can do anything. I can work for them pro bono. I can give them reduced rates just because of animus towards Scott. I can do whatever I want, and Scott's facing that. There's something wrong with that picture. It's balanced against the candidates. I'm going to throw one other unrelated thought out here, just informational, a little historical, has nothing to do with what I just said, but it kind of does. Back before Article 28, there was Amendment 15. Article 28 reflects much of the structure and academic thinking that went into the design of Amendment 15 early on. When Amendment 15 was in trial, there was a case I mentioned with Jim Bopp and so forth back at U.S. District Court. We had a 9-week bench trial in front of Judge Dan Spar on that case. Various constitutional provisions, and a lot of academics testified, including those who designed Amendment 15 and whose thinking went into the structure of, therefore carried over the structure of Article 28. And it was designed to not only prevent corruption and what we were coming off of Watergate and the bags of money being delivered on airplanes to people and all this kind of stuff. I can't remember the term that was used in the McCarthy era for somebody who had a lot of money and made a candidacy possible and wouldn't have been possible otherwise. But it was designed to address that, but also it was designed to even out the financial power among 3 sets of players in the campaign finance community. One was the candidates. Actually, let me back off. One was individuals. The candidates were the recipients of this money. One was individuals, people. We were trying to make sure a third of the financial oomph rested with individual people. Now, it makes a difference, I guess, who the individual is, but at least keep it in that box. The second box was what they call general interest, or general interest organizations, and that translates to political parties. The third was special interests, and we were supposed to have like about a third of the support for candidates and so forth coming from those 3 areas. Now, the result, I'm going to suggest, is it did not turn out that way. The group they were trying most to promote were the general interest groups, the parties. And look what's happened there. The ones who have, Brian Calls nodding his head, having been at the helm of one of them. They have suffered most from the current structure, but it was a very thought out, designed structure. And of course the constitutional laws have changed all over the map since then. I mean, we had days when the folks at the U.S. Supreme Court, the Stevens analogy that money is property, so these First Amendment implications don't come into play with Scalia way down the other end, and now we've shifted the other way. I'm sure we'll go back and forth some more, not real quickly, but we'll do some more. But at any rate, that's just sort of a ramble about how we got here. And on the attorney fee issue, again, I mean, there is a perfect area that I think poses some real issues, and the Secretary of State's got to defend it. Some cases, the Secretary of State has to defend just because they have to defend it, and the Attorney General's office is in there because they have to be, whatever they may think about it. This is one that really matters. I mean, that's an issue that's got to get resolved.
Well, and thankfully the Supreme Court took cert on that.
Yes, it's before the Colorado Supreme Court now.
So I know our time's just about up. I don't know if anyone has questions.
Or comments.
Or comments, yeah.
Comments, especially the judges, please, and you don't have to tip your hands to us because you know you'll be seeing both of us again.
Okay.
Silence, okay.
Well, look, I mean, this whole area is a real challenge, and you do have these shifts in thinking. I think Ed is right. Although I will say Stevens and White are the only 2 that have ever argued fully that it's property.
I knew something was coming.
And to some extent the Buckley framework still remains in place, although it's been, tweaked on the edges here and there and fought over. We'll see. I mean, we've got, now that Trump has an opportunity to appoint a Supreme Court justice, 2 of the people on his list of 21 justices, or potential justices, are people, probably most everyone in this room knows. Justice Ide, the Colorado Supreme Court, and Judge Timkovich, Chief Judge of the 10th Circuit. I mean, they're both on Trump's shortlist. So we could get the second Coloradan in history after Justice Byron White on the Supreme Court, which would be sort of neat. But with that said, my sense is going forward, you're going to continue to see the Supreme Court take a few, their annual whack at campaign finance law, which they did for quite a while. I think the 10th Circuit here is still a little bit divided. I think the Citizens United case was a very frustrating case in front of the 10th Circuit, because there, what you find, I think, the federal court's doing as well is similar to what the ALJs are doing, is, doing sort of narrow as applied or something analogous to that to resolve just that case rather than providing a broader clarity. So the set me free or execute me is a perfect example. In the Citizens United case, Citizens United said, hey, we're a media organization. Secretary of State in our advisory opinion said, no, we don't think you are, even though our opinions are worthless. So CU sued in district court, lost, went to the Court of Appeals, won. But the way they won is and Tinkovich was on this panel, and completely wrong in my view is the way they did this. But what the federal court said was, well, Colorado law has to contain another exception, or a broader definition of the media exception, which now includes Citizens United, since they're saying they're a media organization. So what the federal court basically did was sort of rewrite that part of Colorado law by expanding what the media definition is that's exempt from all these other campaign finance requirements. So now the question coming up in the future will be, and it's analogous to an as applied, well, are you, new media organization that you're claiming you're a media organization, are you like Citizens United with this new expanded media exception under the 10th Circuit? Or are you not like Citizens United, which means you don't get it? And I see Matt nodding his head, saying, it's only a matter of time before we start litigating over what's media and what's not. So that's sort of analogous. The framework becomes similar to your as-applied challenge, but there the court expanded Colorado's law, which is, in my mind, the first time a federal court has ever rewritten a state law in the campaign finance area, but it happens. I haven't personally talked to Judge Tinkovich about that, but it further creates sort of this difficulty and this morass of who does this apply to, who gets these exceptions and whatnot. So that's the challenge we face.
So if I would just add one thing, and I'm not picking a fight with Scott on this, I think he would agree with me completely. If there's one thing that keeps the ship floating, I think, amidst all this complexity, all these constitutional issues, the changing law at the U.S. Supreme Court as well as everywhere else, the exercises of power at the various levels of government, whether Scott can adopt a rule that's, or the Secretary can adopt a rule that's consistent or inconsistent with a statute. The first wall of defense of sanity, in my view, and I'm not just throwing sunshine at the judges, but is the administrative law judges. And it's the ability to sort of sort out and deal with the crazy cases, the gotcha cases, which are not crazy cases, they're real. If somebody doesn't properly do their limited liability company membership attribution, they violated the campaign finance laws. I mean, that's so. And there's nothing, I don't think, unconstitutional about that reporting requirement. That makes sense. So, but if it's a first-time mistake and it was corrected right away and the original contribution was reported in some fashion, the administrative courts, in my experience, have handled these things very, very well. And that brings most of it, not in every case, I'm sure, but in most cases, and that brings a lot of the chaos that could exist to a stop